Hello, this is the international arbitrage on 29th of January 2024. And today we're going to talk about the situation which is international risk. And this involves international raising, whether you are a small US fund or operator. And small in the US is defined as less than $150 million. And I would say outside of the US, those non-US persons seeking to raise funds in the US, anything under US 100 million or $150 million also is going to be viewed as small. And the importance of the $150 million limit, which we talked, is the fact that under US securities laws, you get a number of exemptions if you're raising funds in the US and you have under $150 million under management. But if you have more than $150 million under management, then you have to comply with certain registrations and regulations. The other key thing about the US that non-US persons and operators need to know is that you can't use success fees in the US. You can't hire introducers and finders in the US. If you do that, the investors actually who understand this business will probably move away from you. And if anyone reports your organization for having paid out commissions anytime later, you could be subject to sanction by the SEC. Funds could be confiscated, handed back to investors, and they could be fined, and you could not even be able to raise funds in the US anymore. So when it comes to international fundraising, US operators, owner operators, who want to raise money from international persons, there are many international investors who are outside of the US. They see the complexity of US rules, and they don't necessarily want to engage themselves to be subject to US tax laws. They don't want to be subject to US reporting. They don't want to be subject to US jurisdiction because they're very well aware of the US federal criminal code, things like the wire fraud statute and all the rest of it. And if you get any of these things wrong, you can essentially find yourself having to deal with the US federal authorities. On the flip side, non-US persons, non-US international investors, non-US persons, non-US operators who want to raise money from US persons, you guys have to think about the amount of investor protection that US investors want to require. This is because US private banks see international non-US operations as presenting high compliance risk. US persons and individuals and their advisors also see international non-US operations as high compliance risk. So that means that if you're a non-US operator, what you have to do is you're going to have to find ways to set up either a US regulated fund. The exemptions won't help you because you're a non-US operation. Using the exemptions, just a LPGP, which is not regulated, is not going to give the US investor a lot of confidence. So you're going to want to set up a structure which is regulated so that US investors can be confident that they're protected by US laws and funds and structures and commitments that you have within the US legal jurisdiction. So that's it for now on this video. We're going to expand on these topics in the next few coming videos. Cheers.